Please be seated. I'm not Palmer. Judge Palmer is over here. Judge Torpy is over here. My name is David Monaco, and I will be presiding today. We have three cases for oral arguments. The first is a criminal case, and each side will have 15 minutes with respect to that one. The other two are civil cases. Each side gets 20 minutes. Appellants, let me know if you want to reserve any time for rebuttal. It'll show up on the clock as well, but I'll try to remind you. If you have any cell phones or other personal communication devices, please turn them off at this point. I believe we'll take a break after the second case and invite anyone who wishes to join us for coffee in the attorney's, any attorney who wishes to join us for coffee in the attorney. First case is MAZZOLI versus State. And we're ready to go.
Good morning, Your Honors. Greg Tucci from Ocala, representing the appellant David MAZZOLI. I would like to reserve 3 minutes, if I may.
Hold on for a minute. Let me get this thing squared away. 3 minutes?
Yes, sir.
Okay.
I'd like to start with issue 2, and that is basically the proposition that the state did not prove that the blow struck by Mr. MAZZOLI actually caused great bodily harm, permanent disability, or permanent disfigurement to the victim, Mr. Slater.
He suffered great bodily harm, right?
Yes, sir. I will concede that.
You're just saying that it might not have been from the baseball bat that your client hit him in the head with?
Correct.
Might have been from the other, some other co-defendant?
It really wasn't a co-defendant. It was a juvenile named Smith.
Might have been from another culprit.
Culprit was a good word. Mm-hmm. And Smith was identified in the proceedings. Mm-hmm. Ironically, the state says this issue wasn't preserved for appeal, and with due respect to trial counsel, that's probably the only, there was nothing really to object to at that level, because I think this is a burden of proof issue and an evidentiary issue. When we look at the cases at page 31 of the initial brief, the cases I've put forth, Cunningham v. State, Chesnoff v. State, and EA v. State, in each of those cases, that defendant did a criminal act which was proven to have caused great bodily harm. So the causation, that element of the offense was proven. Cunningham said, well, his was self-defense, but the jury found otherwise. And all of the other cases, Chesnoff, they beat this poor person silly and his head was swollen. And so there was a direct causation. We don't have that in the case before the court today. The state doesn't cite one case to support a legal theory.
Well, there's evidence in the record that your client hit the victim with a baseball bat in the head, right?
Correct. Yes, sir.
And there's direct evidence of that. There's an eyewitness, right?
Yes.
All right. And then the victim suffered a broken jaw during this incident. Is that right?
I believe that's correct.
Cannot the trier of fact reasonably infer from the fact that, your client hit him in the head with a baseball bat, that the broken jaw was caused by that?
I personally don't think that's proper when you take the in concert argument that the state made to the jury. And by that I mean there's ample testimony that a fellow named Smith, some didn't know his name, with steel-tipped boots, kicked the victim in the head and face while he was on the ground.
But isn't there testimony that your client hit the victim in the head with a baseball bat as well?
Yes, sir. But both of those testimonies exist in the record.
And your client is 6 feet 2, weighs 230, and is a shot putter.
Excuse me?
He's 6 feet 2, weighs 230 pounds, and is a shot putter.
That's probably a fairly accurate physical.
He's swinging a baseball bat at this guy's head.
Apparently, that's what the testimony was. Yes, sir.
Can't a jury infer that the broken jaw then resulted from the blow to the head?
I don't think that should be inferred. I think there needs to be some proof when there's an intervening act that could possibly cause the same damage. And the state has that burden of proving beyond and to the exclusion of a reasonable doubt that the act of MAZZOLI caused the great bodily injury.
What sort of evidence would you suggest would be appropriate for that? I mean, obviously a mobile X-ray machine is not going to be out there.
Honestly, to answer that question, I suspect there was no medical testimony, but honestly, I suspect if a physician was called to testify and given the facts, being hit with a bat, the physician would probably say, yes, that could cause this injury. Being down on the ground, had the injury not occurred, being kicked in the head and face with steel-tipped boots, yes, that could have caused this injury. Those are the competing areas to cause the injury, and then you weigh that with the greater burden of proof.
Let me ask you about your threshold. Let me ask you about your threshold proposition, which I guess is.
My light's not on. I don't know what my time is.
Oh, you got 9:54 left.
Oh.
Counselor, does the state have the burden in a situation where there is multiple combatants and there's multiple blows delivered by multiple culprits, if you will? Does the state have the burden to show that that a particular blow resulted in a particular injury?
I think under the facts of this case we do, because we have...
What case law are you relying on for that proposition?
Well, I'm relying on... You see, the state was acutely aware of the problem of linking the causation of the blow by MAZZOLI with the injury suffered by the victim. The state wanted a specific jury instruction based on the Warren case. And the assistant state attorney told the trial judge in the transcript of the proceedings at 150, one of the elements he had to prove was there was permanent bodily harm, permanent disability, permanent disfigurement. The state's concerned about a jury thinking that because of his testimony, other people hit the victim, the damage may have come from those blows rather than the one inflicted by the defendant. And he's looking for a specific jury instruction to get around that so the jury's told about an in-concert attack on the victim, which would involve principle and that type of thing. The trial court would not give that instruction. However, did say that the assistant state attorney would argue the in-concert attack as part of his closing argument. And that's exactly what the state attorney did. He's talking to the jury. This is closing argument at page 159. One of the things we need to touch on is this business of injury, the bodily harm. It's true there's testimony that not only did the defendant strike Slater with a bat, knocking him to the ground, but that someone, who never had any actual testimony as to who, went up and kicked the person on the ground. Well, the testimony is fairly replete, kicked him in the head with steel-tipped boots, but be that as it may. Now, it can be argued, I suppose, that that's where the broken jaw came from. That's fine. But you need to understand where two people do something of this nature, they do it willfully and in concert, meaning they both have the same intent. So he's got his in-concert argument. I inherit this transcript. Unfortunately, there was no objection, and I'll come back to that in a minute, too. The problem is the Warren case, as cited in the brief, and the other case I referred to, they specifically, and even Chesnoff would fit into this, they specifically talk about where two people are pummeling the victim, holding him, punching him, that's acting in concert. That's what Warren talks about. The name of the other case escapes me at this point. But that's what that's the same thing that happened in Chesnall.
Two separate defendants deliver a punch to the head of the victim, one after the other, and the victim suffers great bodily harm as a result of one of those punches. Does the state have the burden of showing which punch caused the great bodily harm? And if so, what decision are you relying on in support of that argument?
Well, I don't have a decision to support that specific argument other than it's not an in-concert act. We have MAZZOLI striking with a bat. That's the end of it. Mazzoli's not in the picture anymore. Nobody even puts him in the scene anymore. We now have independent testimony from a number of witnesses that this other fellow comes in, steel boots, starts kicking the guy in the head on the ground. That's not in concert, I suggest, as discussed in Warren, nor is it as Owens. I mean, Owens was two brothers involved. One grabbed the victim, the other started beating him up. Warren is kind of the same situation, and Chesnall was the same situation. We really don't have that. As to, why counsel didn't object, I kind of think that could constitute a fundamental error of a sort, and I base that on the Strong v. State 853 Southern 2nd 1095 3rd DCA. I misplaced that page, but basically that case discusses absent an objection, an unfair argument to the jury could constitute fundamental error. But in that particular case, the 3rd District Court said, but you have to look at what was said in context of what was the defense's closing argument. Did that give rise or open the door to the state's?
Is that a point on appeal that you made here?
Well, it's a point. It's not a point on appeal other than we've alleged.
We can't do anything about it, can we?
Well, we've alleged that it was an improper closing argument in terms of misleading the jury as to the facts and the law. That has been alleged in issue 2.
Counselor, you got about 3 minutes and 40 seconds left if you want to cover any other subjects.
Well, the other one I would like to look at is obviously the sentencing issue. I've done criminal law for a long time, and the disparate sentences kind of went away with the guidelines, but now they seem to be back again based on the trend in the case law in terms of minimum sentences and guidelines aren't really adhered to by trial judges. I think the third issue on appeal had to do with the mitigating factors we suggested, which were the need for restitution, which is substantial, lack of a prior record, and what else is cited is the fact that there's testimony the victim may have been the initiator and that the defendant qualified as a youthful offender. Thank you.
All right.
Good morning. My name is Lori Hagan. I represent the Attorney General's Office for the state. Regarding the second issue in this brief, as to whether the defendant caused the great bodily harm, I would point out that this issue is not preserved. It was not presented in the defendant's motion for judgment of acquittal. He just moved generally for judgment of acquittal on insufficiency of the evidence and claimed that the witnesses were not credible. He never raised the causation issue in context of the JOA, which is what he needs to do to preserve the issue. And you asked for a specific case. Because he didn't raise the issue in the JOA, there weren't cases discussed at trial, but one of the cases cited by the defendant, the Chesnoff case, involved a defendant who punched the victim, knocked him to the ground, and then the defendant and a friend continued kicking him in the head, and he was convicted of aggravated battery with great bodily harm, the one that originally punched him. You know, this defendant wasn't charged as a principal because there were no other known assailants at that time. but we have ample evidence that he hit the victim in the head with the bat. And in fact, the eyewitness said that the victim was unconscious when he hit the ground.
Somebody said they heard a crack or something like that when he swung the bat, didn't they?
You know, I looked at the testimony. I didn't see that, honestly.
All right, well, maybe.
But they did say he was unconscious before he hit the ground. That's why the eyewitness didn't try to help him get away, because he said he was unconscious. And everyone said he looked severely injured when they ran to his aid before anyone even began kicking him. And the fact that, you know, the state does not have to prove that someone else didn't commit the harm. They just have to prove that this defendant caused great bodily harm, and that's a jury issue. And the jury clearly, you know, found on that issue. Does this court have any other questions as to any of the other issues? Thank you. Then I'll rely on my answer brief.
Go back to the Chesnoff case, which is at page 31 of the initial brief.
Would you address the preservation issue first? Was the argument made below specifically on the lack of causation on the motion for judgment of acquittal?
Honestly, I think we're at a burden of proof issue, which I think is different than a judgment of acquittal. The judgment of acquittal was more or less on insufficient evidence to submit to the jury. And in point 1, we talk about the Tips case, issue 1, and ultimately there was some legal theorizing with some cases set forth in issue 1, but Tibbs eventually came for the proposition that under a line of cases, legally insufficient evidence basically is another way of saying the state didn't prove their case beyond and to the exclusion of a reasonable doubt. I think you can challenge at any time whether the state met its burden of proof in a criminal case.
Well, was the trial judge ever asked in any procedural context to rule on whether or not causation of the injury had been proven? And if not, where's the trial error for the trial court not finding that?
I'm not saying it's a trial error. I'm saying it's a failure of the burden of proof, which I suggest and respectfully submit is different. Unfortunately, I inherited what I would say is not a very good record here, but having said that, it wasn't raised in that context. Thank you.
Thank you.